Let's consider a hypothetical example of religious discrimination in the workplace. So the example we have, Sarah, who is Muslim, applies for a job at a retail store. She's qualified for the position, having several years of experience in retail and excellent customer service skills. During the interview, Sarah is asked if she will be able to work on Fridays, to which she responds that she would need time off on Friday afternoons for prayer. The interviewer notes this and later decides not to hire Sarah, citing her inability to work on Friday afternoons as the reason. Despite the store having other employees who could have covered that time slot. So this is an example of discrimination. How this is discrimination? Because Sarah's religion and her associated practices, her prayer time, were a factor in the decision not to hire her. Despite her qualifications and the feasibility of accommodating her prayer time, her religious needs were viewed negatively and impacted the employer's decision. Why is it discrimination? Discriminating against Sarah based on her religious practices is unfair, as it disadvantages her solely on the basis of her religion rather than her qualifications or performance. It demonstrates a failure to accommodate her religious practices when such accommodations could likely have been made without undue hardship due to the business. Why we cannot discriminate based on religion. Discrimination based on religion is prohibited because it undermines the principles of equality and diversity that are foundational to human rights. Everyone should have opportunity to be evaluated based on their skills, qualifications, and merits, not their personal religious beliefs or practices. Additionally, allowing religious discrimination can create a hostile and exclusionary work environment, which is detrimental to both individuals and organizations. Ensuring freedom from discrimination based on religion also fosters a more inclusive and diverse society, where different perspectives and backgrounds are valued and respected. So, for the second question, give an example of discrimination based upon disability. So, the example. Imagine a situation where an individual named John, who is in a wheelchair, applies for a job as a customer service representative at a company. The job primarily involves interacting with customers over the phone and using a computer, tasks that John is fully capable of performing. However, during the interview process, the employer expresses concern about John's mobility and the company's office not being fully accessible. Despite the job not requiring significant physical movement, consequently, John is not hired, with the employer citing potential difficulties in navigating the office space as the reason. So, this scenario is discriminatory because John's disability, which does not impact his ability to perform the essential functions of the job, is used as a basis for the hiring decision. The employer focused on John's wheelchair use, rather than his qualifications and ability to perform the job tasks, constitutes discrimination based on disability. Circumstances where discrimination might be considered. Discrimination based on disability is generally prohibited. However, there are exceptional circumstances where an employer might not hire a person with a disability, known as a bona fide occupational requirements, BFOR. If the nature of the job inherently requires certain physical abilities that the person's disability prevents them from fulfilling, and if accommodating the individual would cause undue hardship to the employer, then it may not be considered discrimination. For example, if a job requires heavy lifting that a person with a certain physical disability cannot perform, and no reasonable accommodation can be made without incurring undue hardship, the employer may not be able to hire that individual for that specific role. In John's case, however, his disability does not interfere with the job's core responsibilities, and reasonable accommodations, such as ensuring accessible office spaces, are feasible without undue hardship. Thus, not hiring him based on his disability is unjustified and constitutes discrimination. Employers are required to make accommodation for employees with disabilities up to the point of undue hardship, meaning significant difficulty or expense to ensure equal opportunity for all individuals. Third question, I believe. When an employer asks, "Where are you from originally?" before they offer you a job, which protected ground of discriminations have they violated? What is the question you ought to have asked? Explain why this is the law in Ontario. So, when an employer asks a candidate where they are from originally, it can violate the protected ground of discrimination related to place of origin, ethnic origin, or ancestry. Such questions can imply that the candidate's suitability for the job is being assessed based on their background rather than their qualification and skills, which is discriminatory. The question they ought to have asked should be directly related to the candidate's ability to perform the job. For example, if the employer is concerned about legal work eligibility, a proper question would be, "Are you legally eligible to work in Canada?" This question is relevant to the job and does not imply discrimination based on where the candidate is from. In Ontario, the Human Rights Code prohibits discrimination in employment on various grounds, including place of origin, ethnic origin, and ancestry. The law is designed to ensure that employment decisions are based on merit and qualifications, not irrelevant personal characteristics or assumptions based on someone's background. This ensures a fair and equitable job market where everyone has equal opportunity, promoting diversity and inclusion within the workplace. Is it a violation of the Ontario Human Rights Code to not hire a person because they have several tattoos? Explain the law. Whether it's a violation of the Ontario Human Rights Codes to not hire a person because they have several tattoos depends on the context and the nature of the tattoos. Generally, the code does not explicitly protect personal appearance attributes like tattoos. However, there are circumstances where this could intersect with protected grounds. If the tattoos are connected to a person's religion, ethnic origin, or another protected ground under the Ontario Human Rights Code, then refusing to hire someone because of their tattoos could be considered discriminatory. For example, if a person has religious symbols tattooed as a part of their faith, and these are the basis for not hiring, it could be seen as discrimination based on religion. On the other hand, if the tattoos are not related to any protected grounds, and if the employer has a legitimate, non-discriminatory reason related to the job requirements or business needs, such as a strict uniform policy for customer-facing roles, then not hiring someone based on visible tattoos may not be considered a violation of the code. However, the employer would need to demonstrate that the policy or requirement is a bona fide occupational requirement and that accommodating the individual would cause an undue hardship. In any case, employment policies regarding appearance should be applied consistently and fairly to all employees or candidates to avoid any perception or reality of discrimination. Employers should carefully consider whether such policies are necessary for the role and ensure they are not disproportionately impacting individuals based on protected characteristics under the Ontario Human Rights Code.